Yes, we are going live. Hi, Shubhrit. We are live. We can start the webinar.
Hello and good evening to all of you. Let me begin by congratulating LiveLaw, which recently completed 7 years as a website. Now, as a practitioner of law, I can attest to how invaluable a resource LiveLaw has proved to be. But I do think that it's turning into just as invaluable a resource for non-lawyers too, especially for those who are interested in the wider world of politics and governance and the role that the law and the judiciary plays in all of this. Our speaker for this evening is the senior advocate, Mr. Gopal Subramanium. Mr. Subramaniam scarcely needs an introduction, so I'll keep this very brief. Mr. Subramaniam is a former Solicitor General of India, an honorary bencher at Gray's Inn in London, and a member of 3 Verulam buildings, a leading set of barristers' chambers. We are deeply grateful to Mr. Subramaniam for having taken time out this evening to speak to all of us. Now, without further ado, before I really get to the topic for the evening, which is the challenges before the courts, and before I pose my first question to Mr. Subramaniam, I just wanted to have a quick word with all of you to just tell you that should you have any questions, you can place those questions either in the chat box or in the Q&A box, and I'll try and get Mr. Subramaniam to answer some of those questions at the end of the session. To begin the evening, I mean, we're all sort of acutely aware of the plurality of problems that we are faced with in accessing the courts during this COVID-19 pandemic. Now, these are obviously extraordinary times, and there can be little question that extraordinary times call for a number of different extraordinary measures and the placement of a number of different restrictions. But I'm curious to know from you, Mr. Subramaniam, what you think and believe is the true role of the courts during times such as these. How open and active must the courts stay? Is it important that they hear all manners of cases and disputes? Or should they be restricting themselves to urgent COVID-19 related work alone or other supposedly urgent cases? I ask this because considerations of urgency can sometimes be subjective. An old matter, a 10-year-old suit, for example, for some person who might be sort of getting on in his or her life, might be just as urgent a dispute. So therefore, I want to begin our session by asking you your thoughts on this.
Thank you so much, and very kind of you to say these words. I think first is the question of principle, that how do courts perceive themselves in extraordinary circumstances? Even in the most extraordinary circumstances, I don't think that the term closure for courts is fundamentally constitutional. I don't think that courts can be simply closed. I think access to justice and judicial review is so basic and so fundamental that solutions have to be found, methods have to be devised by which access to justice is possible. On the question of priority, I would say that COVID-19 cases would get priority from my point of view, having regard to the human predicament and the situational considerations of such a large number of citizens of India that courts do have a fundamental and primary obligation towards them, whether there is a petition in front of them or there is no petition or application in front of the courts. Then I would say I would rank matters of personal liberty or matters relating to issues of personal freedoms as the next in the pecking order. But the matter of prioritization is also necessary, having regard to the restrictions which these extraordinary circumstances do entail, shall we say, in the larger interests of public health. But on principle, I believe that this is necessary to understand and internalize that courts are such a vital organ of the state that they can never be closed. So the closure of this physical space must open up some other space somewhere. But there cannot be, shall we say, a stoppage of access to courts. This is, I think, very fundamental. Even during the emergency, and I make a point here, that when the emergency was imposed, and at that time, the Delhi High Court was not in the building in which it is today. It was in the old Patiala House building, where the trial courts, some of the trial courts are located in Delhi. And there, writ petitions for habeas corpus used to be filed every day. And there were division benches which would take it up, issue rule nisa in the morning, and proceed with the hearing of the cases. So even in times of emergency, when a proclamation of emergency was in existence, courts always functioned. So I do believe very strongly as a lawyer and as a thinker that courts have to be available in some measure and substantive measure, not attenuated measure, substantive measure to the public.
So you made a number of important and sort of really significant points in your answer in terms of access to justice, which brings me to the kind of court hearings that we've been having across the country during these times, which is sort of the use of virtual courts. And I'm quite keen to get your thoughts on this in terms of virtual courts, not just during these times. I mean, these are obviously extraordinary times, but also during normal times, whenever that normalcy does return. Because many have suggested that it's time that we made a gradual shift towards such hearings. Now, I can see some positives in this, obviously, but I also worry about it. I worry about it at various different levels. I worry about it, for example, at the level of efficiency. Would it really lead to greater efficiency in the justice delivery system? And I also obviously worry about it in terms of the extent to which it might impinge not only on procedural rights, but also on substantive rights, including what you mentioned, which is the right to access the courts. And we also know, and I'm sure there's no better person to speak about this than yourself, which is the kind of difference that physical hearings make in terms of trying to bring and trying to secure relief for your client. That can, I mean, just sort of being in the same physical space as the judge, sensing the mood of the judge, sensing how court is going. All of these things are factors that make a difference in an adversarial system. I'm therefore keen to get your thoughts on virtual courts during these times, which obviously is a matter of necessity, but also during normal times, going forward, how we sort of adapt our justice delivery system in terms of adapting to different kinds of technology.
I think that we can't have any a priori assumptions about how successful would virtual hearings be. But there are 2 points which are important. One is, if you have virtual hearings, the quality of technology has to be very good. If the quality of technology is not very good, I'm afraid it does impact the quality of communication, the quality of understanding, and possibly even the end outcome, however much we all claim a degree of infallibility. The second point, which I would like to make is, it could be useful for cases which can be disposed of, shall we say, or which are preeminently suitable of a certain category, and which can be dealt with so that parties don't even have to make the effort or undertake the expense and trouble of traveling to a court. So this is a matter of some degree of discovery. However, there is no doubt that the courts which are conducted in physical space, they have certain distinct definitions which pronounce them as very superior in quality. There are three of them. One is transparency. The second is accountability to a very wide audience, because all court proceedings in India, unless they are held in camera, which are very few, very, very few, are meant to be conducted in the gaze of the public. And it is necessary, therefore, to consider the advantages in a physical space. The third is, of course, in the matter of conversation or the dialogue between the bar and the bench, the conversation, the manner of posing questions, and the ability to retrieve information in a physical space is also substantially different. So courts in physical space in normal times definitely ought to be the rule. And it does conduce to justice. And even if social distancing restrictions, I would say physical distancing restrictions, because the word social distancing could have a slightly pejorative meaning. So I'm saying physical distancing restrictions have to be observed. They should be observed. And gradually, I think the physical space must be looked at as a distinct possibility. But the physical space is primarily the space. But I would not rule out or write off virtual hearings as being useful for certain categories of cases, which I can think of. Let us say a transfer petition in a matrimonial proceeding, for instance, where, parties may be inconvenienced. Proceedings of certain kinds can be dealt with through the virtual medium also, but underlying caveat is technology and its quality. The quality of the picture, the quality of the sound, that is necessarily, it has got to be of high quality.
And I would presume that when we speak about technology in terms of the quality of the discourse and the ability to communicate with each other, we also need the attendant technology, which will allow us to access a number of these files digitally, etc., which also, yes, I think is a big problem today.
I completely agree. I think there have been many initiatives which have been taken by the courts. We have an e-committee in the Supreme Court, which is headed by Justice Chandrachud. He has taken also some initiatives in working on the all India level with the e-courts project. But I think there can never be a complete shift over. And I don't think there should be a complete shift over. So we can, however, use this medium to great advantage in terms of efficiency, in terms of costs, in terms of, shall we say, even access to justice. We can use it to advantage.
So I just want to move slightly away from this sort of discussion on the virtual courts and in terms of access to justice to slightly more substantive issues. And I'd like to get your thoughts on some of the more recent COVID-19 related controversies, if we can call it that. I mean, we know that, for example, that a number of high courts have intervened in cases concerning persons wanting to return to their home states. And the Supreme Court has also done so, albeit some might say a bit belatedly. A number of people have suggested that these are not the kinds of disputes that courts should be involving themselves with. Arguments have been made in terms of separation of powers. Other arguments have been made in terms of generally how ill-equipped perhaps a court might be to deal with issues of this kind. But we can see that at the same time, the crisis is of such a nature where the impact that it's had on basic fundamental rights, I mean, on the right to life itself and on the right to equal treatment, has been immeasurable. I'm keen, therefore, to get your thoughts, Mr. Subramaniam, on how you see the role of the courts in resolving disputes of this kind. I mean, obviously, there are a number of different mechanisms that the court has evolved over a period of time. For example, the use of a continuing mandamus and other such reliefs that have been granted, other such prerogative writs that have been used by the courts. But how do you see, or how do you envision the role of a constitutional court in deciding matters of this kind?
I think the challenges which came up before the Supreme Court in earlier years were not of this particular kind. And the consciousness of, shall we say, social action litigation, or litigation to relieve or give redress to people on the basis of awareness of fundamental inequalities in our society was not adequately manifest. But once the court abandoned, shall we say, its conservative position and moved forward into a position of actualizing rights, I think the situation then for the court is it can never regress from that position. And it ought not to regress from that position because it is a forward-looking position. The second point which I wanted to make is that the right to petition courts in our constitution is a substantive right and is also a fundamental right. It is, strictly speaking, as fundamental as existence itself. Now, why is it that the Constitution provided for these substantive remedies in the context of fundamental rights? And what would be its relevance, shall we say, when the existentialist situation of citizens itself is at stake? I think there, I feel that courts have an obligation. And the obligation is to the Constitution. The obligations which they discharge is not ad hoc in character. It is founded on firm iterations of jurisprudence, in my view. And the firm jurisprudence for that is that they are not attempting to usurp the executive function. I think that is a completely mistaken perspective. They're not trying to overreach, but they have to make it possible when something stares at them that they have to act. Because the one thing which our constitution, at least the refrain in terms of judicial power, is that judicial power in our constitution is not an inert power. Judicial power is also not a containment strategic power that you keep people in their respective domains. That is not the way our judiciary is intended to function under the Constitution. It is true that if you trespass into territories which are totally unmanageable, or what we call as judicially manageable standards, that is a different territory altogether. But that is not the territory we're talking about now. We're talking about issues of very simple nature. People have a right to move freely. People have a right to return to their homes. People have a right at least to some basic drinking water. I think this is something which, with great respect, cannot even be put in controversy. And I also want to make another point here. These proceedings must never be seen as matters of contestation at all. These are proceedings which are primarily non-adversarial in character. They are actually collaborative. They have to be so collaborative that the focus must be only on solutions and seeing that there is a certain level of jurisprudence, that if our constitution is a transformative constitution, certainly the judiciary in extraordinary circumstances will resort to extraordinary measures, orders, directions to make sure that the rights are actualized. we must bear one thing in mind, that fundamental rights are not platitudes. They have to be seen. They have to be experienced. And the experiencing of these rights is something which the courts are obliged to impart to citizens. So I am very clear that there has been, with great respect to the other point of view, I do not believe that there has been an overreach. And I think this is what courts are for. There is a provision in the Constitution, and I would like you to please look at it as a scholar that you are. That is Article 32.3. And Article 32.3 said that Parliament can, by law, actually invest courts other than high courts to perform the same functions as are being done by the Supreme Court under Article 32.1. And that is so important for understanding how necessary it is that all the tiers of our judiciary, they are subordinate courts, they are called subordinate courts, but they are courts of judicature. So also are high courts, and so also the Supreme Court. All of them find a place in the Constitution, obviously, to give relief. So I think the emphasis here is on the fact that courts have a great obligation to themselves and to the citizens and to the Constitution to see that actualization takes place in difficult circumstances. And crafting of remedies, let me come to that point. Crafting of remedies has been a skill. It's a part of the judicial skill. Courts, the Supreme Court in the past has appointed commissioners, right from the time of Bandhuwa Mukti Moksha. Any number of commissioners have been appointed to ensure that, that directions can be carried out and can be overseen. And today the advantage which courts have is you have also the judiciary, which is subordinate to you in respect of high courts. You have the Legal Services Authority. You have statutory boards like the Juvenile Justice Boards. You have the National Commission for Women. You have the other statutory authorities, human rights. There are any number of bodies who all should collaborate in such ameliorative measures. I think I feel very strongly that courts can never be criticized for ensuring redress in difficult circumstances. And they are not in any sense taking over the executive function. In fact, on the contrary, sometimes, you see, we have such a population in our country, and the percentage of people who belong to the class of moving from one city to the other, this is a sector which is an unorganized sector. Its numbers are enormous. Now, with reference to these numbers, they also pose a certain challenge, even to the best of executive governments. So I believe that courts have complete jurisdiction. The other thing is that these are also not matters, as many people are viewing it, as matters of a certain class. They use the expression migrant labor. I feel that it robs them of their civil status. I maintain the position they are citizens of India. The fact that they are in that awful situation is due to no fault of theirs. And in that situation, whoever can help with the authority of the state, I don't mean as an extended arm of the government, I mean as a part of the state, I think is very necessary to do that.
So there are 2 points that you made in response to that question, which I want to sort of explore a bit deeper with you. One is that the idea of social action litigation, or PILs, or however we might want to call it, as being non-adversarial proceedings. And this has been a point of contestation. And it's been a point in which a number of scholars have critiqued the Supreme Court, in the sense of treating the PILs somehow as a separate class of litigation. Would you think that such a critique is fair, in the sense that wouldn't you say that even in a PIL, the Supreme Court should still adhere to basic standards of evidence and trying to glean out the facts of a dispute? before it actually sort of hands out a, a judgment or an order. And of course, you mentioned the appointment of commissioners. But we've seen in many cases where the original petitioner before the Supreme Court is sort of virtually shunned and kept out of the picture, where the court then appoints an amicus or appoints commissioners, as you mentioned. Is that something that you would see as a valid critique? That's my first question. If you want, I could come to the second question once you respond to this, if you think that that would be...
I would like to respond to this question. I think this is a valid method. The reason for that is that what the court sees in front of it as justification for embarking on this course of either appointing an amicus or substituting, let us say, like in Srila Base's case, the Supreme Court Legal Aid Committee was appointed as the petitioner once the petitioner wanted to be discharged from the case. The reason why the court does that is that the issue which is brought before them is far too important and far too significant in terms of the Constitution. And there are two kinds of public interest litigations. One, where there are facts which are alleged, which may require a return or a rebuttal, and so on and so forth, or where some evidence would be needed, where some degree of gleaning may also be necessary. But the others are cases of PILs, which are, let us say, which raise issues. And actually the issues do pose constitutional questions, or even cases relating to, let us take the case of even environment, ecology. These are also cases which have a bearing on the fundamental rights of citizens. So also shall we say rights relating to the Adivasis, the tribals, the people who have been divested of their land in an illegal manner. These do raise fundamental questions. And I think by taking on board these causes, the court actually, as I said, it has moved away from a conservative position to a position of intervention. But the intervention which it undertakes is either an interim intervention until Parliament or the executive government itself intervenes and frames a policy or legislation to deal with that subject matter, or it passes directions which would at least hold the field until Parliament gets a chance to frame a law. Take the case of Vishaka, for instance. Now, that's a case where guidelines were issued. Now, that's a case which is one of issue. It is one of equality. It is one of, shall I say, non-discrimination at the workplace. It is very fundamental. It is one of the most important principles to be recognized, which has been recognized. And our country, our courts, are far ahead of many other jurisdictions in many matters of such importance, because they have viewed it as engaging certain areas of the rights and the Constitution. And I think, therefore, I would say that the use of the word activist or the use of the word activism, I think it is just a label. It doesn't mean very much. I think what is important is the engagement by the court with issues which arise before them. So when I say some matters are not fit for contestation, the other side, if it is the government, must see what is the point which is being made here. If the point which is being made here is one which needs some investigation, needs some inquiry, needs some response, needs to be even formulated, I think it is a matter of great importance. I'll give you one example. Chief Justice Kapadia was once hearing a petition, and the petition was whether people who have HIV, what is the level of treatment which the state must offer them? Is it only line 1, or is it also line 2 and line 3? And the intervention, even just a nod from the court to examine the matter, and I say it with great admiration, again, in respect of some civil servants who had the sensitivity to take on board the issues involved. in matters of public health. And they framed a very benign and beneficent policy. And we are one of the first countries which went and progressed very highly in the matter of HIV control and treatment.
So the other point that you made was with respect to crafting of remedies. And this brings me to a larger question in terms of where you might see the Supreme Court standing today as an institution. Because during this PIL era, we've seen the fashioning of a number of different rights, where the court has read into Articles 21, 14, 19, etc., a number of different fundamental rights. Now, we haven't possibly seen a concomitant movement in terms of the remedies that the court has handed out. Now, one of the more recent and notable instances concerns the case of 4G internet in Kashmir, and as well as internet in certain other parts of India. And of course, the judgment that the court first handed out in January, where it found that the right to access the internet is almost or is an extension of either the right to freedom to do business or the right to freedom of speech and expression. The court has recognized this, therefore, as a fundamental right. And to that end, it must be commended for doing so, because this is a progressive step, as you mentioned. But we've not possibly seen that translate into the grant of reliefs. So where do you see the Supreme Court sort of going forward in terms of how it might help fashion relief in cases such as this? And how do you see the role that it has played over the last few years, transforming itself and really taking this to its logical extension, and to its logical conclusion, where the fashioning of rights also turns into the grant of remedies to petitioners? So how do you see that playing out?
First thing is that I have always felt a bit puzzled, because even prior to the enactment of the Constitution, in common law, ubi jus ibi remedium, it always existed. And you can't be worse off after the Constitution. You only had to be better off after a Constitution conferred rights, recognized rights, and provided for access to justice through courts. So I do believe that the only way for the court is always to go forward, and it has to fashion itself as the protector of rights of citizens. The second point which you made is, while you acknowledged the correctness of recording the interpretation on the freedom of speech, but yet the relegation of the final remedy at the hands of the executive. This is a debatable point. Now, there has been a view, but again, that is a conservative view, which is you issue a certiorari coupled with a mandamus and relegate it back to the government to review matters. But I think in matters of fundamental rights, now I would apply that, let us say, to a case relating to an auction or a tender where you have a certiorari coupled with a mandamus. But in matters involving fundamental rights, I always believe that the courts must take upon themselves to lay in very clear and uncertain terms the logical consequences of what they think is the right. Because otherwise, you see, the final relief is what counts. So when you say it is, you must also have the willingness to go a step forward. But I would say that this is a transitional process. It is not a process that, because in one judgment it has been left to the executive, therefore that is necessarily a pattern. No. I think the court, I would say, with respect, is conscious of the enormous amount of prestige which it enjoys in the profession. I don't think that it is unmindful of it. It would be unfair to even suggest it. It would be uncharitable even to say that. However, the situation like the present one, for instance, this is actually a moment of history for jurisprudence. Why? Because in difficult situations, unmanifest rights become manifest. The COVID-19 situation, nobody thought of COVID-19. Nobody thought what are unmanifest rights. But in such situations, new rights can emerge. This is the point. They are born out of human existence. The right to clean drinking water at the moment is a right. It is an unmanifest right, but it has been manifested by a changed scenario. This requires attention. This is a moment of history for the court in terms of jurisprudence. It should never lose this moment, in my view. It is a moment of such history because a court can actually lay the very nature of rights. As you know, Darrell Levinson, the famous professor, he said that you need sometimes what is called an equilibrated remedy. And I always wondered, why did he say that? He said it because more often than not, rights look wonderful, but remedies look very weak. So the remedies have to match the rights. And that is something which is possible for the court. So these are moments of history, while there are moments of extreme pathos and extreme, shall I say, concern. But there are also great moments of history for the courts. Lay down jurisprudence to lay down, because they are also people who influence a positive opinion in the minds of people. The opinions of the judges in this country, they carry weight. People read them. People are persuaded to consider the logic in these opinions. So I believe that this is a moment of history for the court to consider, that apart from these interim measures which are being attended to, they must also place it, in my view, on a great jurisprudential footing, because it is one of the most celebrated moments of the court's history, that it recognizes that rights are never static. Rights can actually acquire a continuum, and that continuum is what the courts have to recognize.
Subramaniam, I have two more questions before I open it up to the audience. The first is, we're seeing that to a number of different problems that we are faced with, the kinds of solutions that are being offered are technological in nature. And I want to get your thoughts on how you see the courts handling disputes of this kind, where the nature of judicial review calls for a fact-intensive inquiry, and often an inquiry of complicated facts that might be rather difficult for judges to comprehend, perhaps without taking assistance from technologists. Now, I'm concerned here even about cases, for example, such as the challenge to Aadhaar, in which you played a big role, or more recently, the introduction of applications such as Arogya Setu and challenges to that. How must the court go about its job of reviewing laws predicated on providing digital solutions to problems? And that's my question.
It's a wonderful question. You see, the Arogya Setu app in the present condition, where it seems to be scientifically reasonably established that contact is a means of communication of the virus, the application of this app through a digital solution seems preeminently in public interest and in safety and in the welfare of citizens. But I think because of the fact that it records the details of a person, it contains personal information of some kind, the app must be capable of living only up to the time the virus lives, after which it must find its way elsewhere. Secondly, the app also must be administered by health bodies, that is, people who are dealing with the subject and are not necessarily going to use this information for any other purpose. So if we give it, shall we say, the efficacy for the period for which it is intended, it is perhaps justifiable. But we must always keep in mind concerns of privacy. We must also keep in mind the custodians of this data. That's very necessary. It should not fall into private hands. It has to be essentially organs of the state who care about the health and safety of citizens. So I would say, at best, a pro tem measure, but not it should not be an entry through the back door into the lives of people. No. Sorry, one more thing you mentioned was, how does a court deal with this in terms of a fact-intensive inquiry? I think it is possible for the court to get evidence. And I think the traditional hands-off approach, whenever it became a little, when it exercised the courts, is no longer the situation today. You see, today, one of the things which we must appreciate is that judges understand the intersection of law with other disciplines of knowledge. They see that law is actually a very crucial center point for understanding right from sociology, philosophy, morality, ethics, and it can be whatnot. But most importantly, you can use law as a lens or a prism by which you can look at any form of discipline. And one of the interesting subjects which is being studied is the very idea of a normative structure because of law, or law as a norm, was whether it helped cognition. And I'm saying this with some degree of consideration. The Constitution is the highest rule of reason in our country. There's nothing which is higher than that rule of reason which governs us in this space. In this country, it is the Constitution. And that is the rule of law. In that Constitution, it is that rule of reason. So our cognition must also be tailored to those values. That is necessary. The cognition must arise out of those values.
Finally, Mr. Subramaniam, I'm very keen to get your views, especially as a former Solicitor General of India and as a distinguished member of the bar, on a divide that appears to be forming between various different members of the bar, and how that might impact justice delivery by the courts. I'm speaking here more specifically about a number of articles that have been written over the course of the last 2 to 3 weeks in terms of responses to submissions that have been made in court and whether they ought to have been made, and in terms really of the role and responsibility of lawyers, of advocates who are representing private parties before the court, as well as advocates who are law officers before the court and who represent different governments. And I think we can all agree that there does appear to have been some sort of a division that has seeped in. And I'm therefore curious to know from you how we must respond to this, what should be the kind of measures that we take in order perhaps to resolve this, and whether you think that that will have a bearing at all in terms of how the courts go about deciding disputes and delivering justice.
This is a very vital question, and one must not shy away from answering this question. There are 2 points here. The first is, how does the legal profession see itself? Do we see ourselves as a divided house, or do we see ourselves as a unified house? If we are a unified house, what should unify us? That is the question. And I'm very clear in my answer. It is the independent legal profession. It is the independence of the profession which is the unifying answer. What do I mean again by independence of the profession? You can have your own political inclinations. You can have a certain ideological point of view. You can even have a divide. But professional space is a very, very important space where independence has to be preserved at all points of time. At all points of time, irrespective of your ideology, irrespective of whatever may be your anchoring anywhere, you have to keep it completely outside you when you are actually a lawyer. Now, I want to say this because in my observation in the yesteryears and the opportunity which I had of seeing lawyers in earlier generations, what stood them out, I think, was the lack of being identified with somebody or something. They were independent. They could appear for anyone. They could appear for any cause. They had that ability to be mobile. Their independence was itself such a cherished virtue. So, for instance, I'll give you a few examples. In S.P. Gupta's case, the petitioner, one was Mr. S.P. Gupta, a very leading lawyer from Allahabad. The other was, of course, Mr. Chagla, Iqbal Chagla, again, a very distinguished and senior lawyer from Bombay. The case was argued by Mr. Sirvai, and Mr. Sirvai made it a point to stay here, notwithstanding the strain on him, but he stayed and argued the case right till the very end because it mattered to him that the independence of the judiciary was really a part of an extension of the independence of the bar. So we all are bound to this principle, unifying principle of independence. Now, this is of great concern to me. If tomorrow, let us say, the profession becomes completely politicized, let's take a point of order, then what will happen is that this will become completely an alter ego. Professional lawyers will become alter egos of political apparatus, which again degrades them as lawyers. So I'm very clear that the only unifying factor is the independence of the profession. And this is very necessary because if you are fractured here, the courts also may be fractured. This is, it is like one arm reaching out to the other. So I think that all efforts must be concentrated on the middle ground, which is the independence. This is not personal. And this is not the time you can have any views, shall I say, but these are not the times of diatribes or any personal comments, no. The second point which you said about law officers, they are called law officers because of a certain tradition. And I had an occasion to investigate this in some length. You see, they are officers of the law. They are not officers of the government. This has to be very clearly understood. They are officers of the law. Why are they called officers of the law? This also needs a bit of explanation. That is why you will notice under the Contempt of Courts Act, the Attorney General or the Solicitor General, now of course the Additional Solicitor General, now we have any number, over a period of time the posts have increased of Additional Solicitors General, have the power to sanction in contempt proceedings. Why? Because they are officers of the law. They are actually meant by wisdom and advice to restrain even their client, which could be the government, from an action which they think is not correct. It is that which imparts them the quality of what is called as a law officer. In fairness, I must say, that I do believe optimistically that all persons with the best of intentions, sometimes there could be a little over a remark here, a remark there, but I think people do sense deep down what they must do also. So I think if one were to look at this positively, in a participatory way, the profession being, as I said, a very important profession, and it is the most important bulwark in a democracy, I think it is perfectly possible to iron out this perception. And law officers have a tradition. And I'm certain that every law officer will be alive to those traditions. And there have been outstanding examples of this, Jana. So I do wish to say that while differing points of view are possible, and it is perfectly open for someone to express a conservative point of view, a Mark Tushnet school of thought, another person to express another school of thought. But the important thing is the space in which they express it. That is very necessary. It should not look that they are expressing it dehorse the professional space. This is very important. In the professional space, you can argue whatever kinds of realism in philosophy which you like, but you need to be careful there.
Thank you very much, Mr. Subramanium. I'll just try and pose some questions which have been, a number of questions have come in, and I'll try and pose a few to you, and time permitting, you can choose to answer some of these. The first question is from Sanjay from the Campus Law Center. And he says that given the centuries-old history of habeas corpus in common law, as a second-year law student, he feels that the Supreme Court is not respecting its sanctity enough. So the question to you really is, what is the logic of reversing the life and death urgency of a habeas corpus petition into something where weeks or months pass by even before the matter is heard? And why is this the case, and what can be done about that?
I can only say that we have to be hopeful that this is perhaps a one-off case. This could be with some justification, which we are not able to see very clearly on the other side, because there's nothing which is appearing to us. But nevertheless, the point which has been made, and I wish to say this, cynicism does not help anybody. And courts are our safeguards. By speaking about the institution somewhat derisively, doesn't take a point any further. If courts have to be strengthened, they have to be strengthened by respect and a point of view for a conversation. But that is the way they have to be strengthened. But the point made by the gentleman that habeas corpus petitions are matters of primacy, I'm sure the court will be alive to it. I think that sometimes a few fleeting moments must not define the history and the destiny of a court. While I completely take the point that even one person's right of liberty is as absolute as anything else. It is an absolutist proposition. And I take the point, as I said, each one of the people about whom we are referring to, each one of them is an autonomous entity, an identity who is entitled to full respect. So the point is well taken.
The next question is from Anurag Parikh, and he asks, what do you think about live telecasting of court proceedings? And after the 2018 judgment of the Supreme Court in Swapnil Tripathi's case, your views on the live telecast of court proceedings.
Well, live telecast of court proceedings is not a unwelcome step. It would only add to the, shall I say, a certain degree of access to witnessing court proceedings. It also leads people to gauge how court proceedings are conducted. It doesn't become a matter of mystery or mystification. So I don't see anything wrong in court proceedings. Incidentally, I needed to add that some of the high courts seem to have web links. You can access them through the web link. And it's a very good idea to have web links or important cases, constitutional matters, to be witnessed through the web. It could be very productive.
I'm sorry, just 1 second. I'm just trying to scroll and find the questions. This is a question from D.K. Jaina, who's an advocate in a district court in Odisha. And his question is, he says that the people are being denied the right to access the courts except for bail matters and other urgent cases such as payment to petitioners and MACT cases, and nothing else is taken up, not even other civil matters. The virtual courts are meant to work more effectively to meet the litigants' needs, but none of these cases are being taken up. So should they be taken up seems to be his question. I know that you've touched upon this during the course of the discussion, but if you'd like to add anything more to that in specific response to his question, then.
I think so far all solutions have been pro tem, interim solutions by courts. I think their reduced work has been purely on account of public health and safety factors, because even papers have to be brought in by the staff of the court or the judge. So I think there have been these primary considerations which actually reduce the workload as far as the courts are concerned. But if suppose, let us say, the situation were to continue for a little while more, of which I think also a forecast should be made, the courts will have to review their position and may have to expand their horizons, subject to, as I said, improvement in technology.
Sadiq Ramzan has a question on sedition and whether you think that the criminalization of sedition, in the sense through Section 124A, is in violation of norms of democracy and is in violation of fundamental rights. That seems to be his question.
You see, it is a very antiquated provision. I mean, it is not free speech. The simplest way to curb free speech is to allege sedition. And therefore, the use of that provision for curbing freedom of speech, or the proclivity or tendency to attract that provision in curbing freedom of speech, is a very serious danger. It is a very serious threat to the freedom of speech.
Raghu has a question concerning the AGR case, where, and his question is more general in nature. So he says, can judicial review impact economic outcomes on competition, financial systems, etc., which are basically policies of the executive, unless such policies are opposed to public policy or are unfair or anti-competitive in nature? And he says, given that economic justice is there's a yawning gap in India, don't you feel or think that judicial review needs to keep in view the current context of economic and social developments?
There are two aspects here. One is, shall we say, matters of economic policy on the one hand, which are framed by the government, which is primarily an executive function. The other is to be conscious of the yawning gaps between people who are affluent and people who are at a very disadvantaged condition. The two are different things. Now, even in the first, I'm of the view that while there may be a policy, but if in the matter of its administration, or if the policy is patently discriminatory in its application, it can be a matter for judicial review. The fact that it is a matter relating to economics or economic policy should not dissuade the court if it otherwise finds it foul of a constitutional principle. The same would apply to any other branch which has been mentioned. As long as it attracts the parameters of judicial review, I think the courts can examine it. But the courts then have to tread a little carefully. They have to see whether this is within the realm of objective policy making. They can't use a subjective lens there. They have to see whether it is within the realm of objectification. And if they see yes, it is possible to actually view it from the standpoint of a pure policy measure with which a court is not concerned, they can decline to apply the lens of judicial review. But where, let us say we have cases where licenses are granted, and I'm conscious that in many cases a criticism has been made that, well, a judgment was delivered that actually led to a certain degree of disincentive. But that is, if I may say so, the principle all over the world, that when anybody invests in any country, you subject yourself to the jurisdiction and the laws of that country. As you would recollect, the margin of appreciation principle, which was adopted by the European courts, but the domestic court said that that is not the principle we apply. We apply a more substantive principle of legality in the matters of adjudication.
The next question is from Jude Rohit, and his question to you is, he asks what your opinion would be on the practice of sealed covers and the use of sealed covers as a mechanism to appreciate evidence. And he says that given that it is opaque, does it not raise raise questions of in terms of perception of outcomes and judgments, and how you see the use of sealed covers as a matter of evidence?
Well, this has been a slight departure from the past. In the past, sealed covers could not be tendered. You had to necessarily put your case out on affidavit. And a person against whom allegations were being made had necessarily an opportunity to rebut what was being alleged against you. Now, in my view, even if these covers are tendered, the court must immediately see whether there is material which adversely affects the case of the petitioner. And if it does, it is to be put to him. Otherwise, there is a failure of justice. That's my personal opinion.
I'll just take one last question because I think we've sort of run out of time. So I'll just try and...
No, you can go ahead. I'll be happy to answer questions.
All right, I'll just then take a couple more questions. Shakti who's a student in the UK, is wondering if the new data protection bill, which Parliament proposes to float, how far it would work as a model and be useful in India. And her question is whether we should look to replicate something like the GDPR in the UK, and what your thoughts on that are.
The GDPR is a good example to start with. It is a pretty sound example. It's been arrived at after a lot of consultative processes in Europe. So we could use some of these examples, but we might have to make some adaptations to our own society and our own jurisdiction.
There are a number of people, who've asked similar questions concerning the collegium system and whether you see any necessity for a commission for appointment of judges in the manner in which they might have in the UK or in South Africa. There are at least 3 or 4 questions on this. And, I'm not naming the people who've asked the question because there seem to be a number of questions on this.
I would like to answer the question this way, that we might have to do a proper analysis of the outcomes which have been delivered by the collegiate system of appointments. There have been outstanding appointments also as a result of the collegiate system. So we might have to do a very carefully factored analysis before we come to a conclusion in the matter. The reason why the collegiate system was possibly adopted were, I think, 2 considerations. One of which was arm's length from the executive, because the court at that time felt if the executive had the final say and shall we say, constituted the court of candidates who felt more prone to being aligned to the government, they felt it would violate the principle of the independence of the judiciary. The independence of the judiciary is inbuilt into our constitution, also because of the Declaration of Human Rights, the very first 1948 declaration as well. So the impartiality component, which is needed for the avocation of adjudication, necessarily requires people to be selected on the basis of merit and competence. This is one part of the answer. The second part of the answer is the ability to judge people arises by judges who see people appearing before them with whom they are familiar, whose ability can be forecast as judges. You see, there's some amount of second guessing which is to be done when you select people as judges. So they would see whether the temperament was suitable, whether would he read enough, would he expand his consciousness. The test which was adopted earlier, at least one Chief Justice, he is no more in this world, but he had the grace to tell me he was appointed at a very young age as a judge in Madhya Pradesh, and he later became the Chief Justice of India, was Chief Justice S.M. Sikri was the Chief Justice at the time. And he had to sign off on his appointment. And he knew that he had the prospects of a progression to be a future Chief Justice of India. He could come through the ladder. So just by way of abundant, caution, he invited him for a cup of tea and, just had a conversation. And in the conversation, he was able to gauge that the man would be preeminently suitable, and he came to be appointed. And the Chief Justice mentioned this as an instance to indicate that sometimes we have to make forecasts of people, and it's not that the forecasts are always right. Sometimes they're right. Sometimes you're deeply disappointed. So this is a bit of there is an element of risk in expectation as far as appointments are concerned.
The next question is from Prashant Padmanabhan, and he wants your opinion on judges taking up various different post-retirement positions, whether it's becoming governors of states or places in the Rajya Sabha or other appointments to other tribunals, etc., and your opinion on that.
I think this is to be left to the conscience of the individual. This has to be left to the conscience of the individual. What does he perceive in that office? What does he feel he can contribute in that office? It is entirely left to the individual's perception. However, I would add, I'm not talking of a governor. I'm saying I am not very enamored at the tribunalization of justice. This itself militates against the independence of the rule of law. The second is judges post-retirement being appointed to the tribunals is also, again, it can dilute the independence of the judiciary. That is what I would say.
Thank you very much, Mr. Subramanium. I think I think we can wind up with that question. And I don't think there are any others which are necessarily different from the sort of questions that you've already...
You just exhaust your scroll and you can tell me.
Yeah, I just give you... Because it's sort of slightly difficult to do this while... Rashmi Ranjan Mohapatra wants to know your views on reforms in the functioning of the subordinate courts in terms of jurisdiction, the independence of the subordinate judiciary, and how and whether you think that serious reforms are needed in fixing the subordinate judiciary.
I have to say something very creditable about the subordinate judiciary on overall reflection. They are the courts of the first instance. And in many places, they have shown such exemplary courage that it is very creditable. And as I told you a little while earlier, under 32.3, that is one of my very, very overarching considerations. This hierarchical system, and the word apex, I would say, is not the right word to call the Supreme Court. It is the Supreme Court. And the Constitution really contemplates a trilateralism in courts, if you know what I mean. You have courts in the first instance, you have the high courts, you have the Supreme Court. But the Supreme Court also has the ability to correct, by virtue of its appellate powers, any errors of law or fact as it may be. But this is very different from any other form of jurisdiction which should be claimed. There cannot be a jurisdiction, let us say, for chastisement. That is not possible. I don't think the Constitution ever contemplated this as a function. I don't think the Constitution ever contemplates that. So the judiciary has to have a lot of respect, mutual regard for each other. And therefore, you know, the tradition that very often when inspecting judges would go, they would avoid any form of hospitality by the judge was a part of the fundamental principle that as members of a fraternity who are judges, we have to show a lot of respect to each other, a lot of respect. And I would only say that since some of them are law students who are asking these questions, that whenever they get time, they must look at the works of Dr. Ambedkar. The Constituent Assembly debates are just a very small fragment of his contribution. They're so small that they don't do justice to the man, Ambedkar. The justice which you can see, I mean, what is his genius? How did he put different ideas together in our Constitution? It is a riveting exercise of discovery of genius.
The next question is from Rachna Joshi Isar on your suggestions to remedy the malady of scant representation of women in the judiciary. Now, of course, one thing that the courts can do is to appoint more women, but she wonders what your suggestions would be in terms of how this can be remedied.
I'm of the firm opinion that considerations of gender equality are very vital, very vital. I firmly believe that whenever one sees talent, they must be promoted. It is very necessary. It is extremely necessary. there has to be an equal level playing field, particularly in a patriarchal society, I'm afraid.
So there seem to be a few questions on the proposed decriminalization of Section 138 of the NI Act. I'm not sure if it's quite directly relevant to the topic at hand, but I mean, if you're keen to answer that,
Well, you see, the reason why it was made an offense was really that a man who had signed off on a check must abide by that negotiable instrument. But there are arguments also in favor of decriminalizing this issue. But unless and until you have a remedy, an effective remedy of recovery, decriminalization by itself will not be sufficient. There must be a remedy for recovery, which is a quick shot remedy, a summary remedy.
Right. Again, a number of questions on this, on the law concerning the grant of bail and why there seem to be so many different sort of divergent opinions on this. Aarti Nath and Rupesh, for example, both wonder and want your opinion on the challenges a court faces while granting bail. I mean, if conditions worsen, that seems to be her question. Rupesh's question is, bail is the rule and jail is an exception, but there seems to be a deviation from this rule. Why is this happening?
As I said, these are all hopefully matters of a transient nature. The general principle is, of course, to preserve liberty, unless there are compelling circumstances to restrain people. Otherwise, they must be of a compelling nature, right, but they must be discoverable by objective standards. This I need to mention. When a court denies bail, it must be able to form an objective opinion that refusal is warranted.
Final question, Mr. Subramaniam. This concerns the rights of an accused to privacy till he or she is convicted by a court of law, and whether it is okay or all right for the media to try some of these cases sort of in their realm, and in the process to violate the rights to privacy of these accused. I mean, I think a more general question also in terms of the link between the right to free speech and where it might sort of tread upon the right to privacy of another person.
You see, there are two aspects here. Sometimes when a process of law is not set in motion, or when there is something tardy happening, journalistic freedom, freedom of the press is essential for bringing to the fore what is in action. But after that stage, when it comes to the question of how the person is going to be dealt with by a court, a trial by media is not the right thing to do. It can seriously prejudice individuals, and it can impose, although we have any number of judgments which say that judges are of a trained mind and they don't get influenced by the media, but we're all human in some way or the other, and it requires extreme resoluteness, shall we say, of disposition not to read what is happening. So I would say always that there is an element of self-restraint which the media should observe in matters of trial by press.
Thank you very much, Mr. Gopal Subramaniam, for having taken the time out today to speak to all of us. I also thank the audience for their questions and for participating in the session. And finally, let me conclude and bring this session to an end by thanking LiveLaw for hosting this and for putting all of this together. I wish all of you a very good evening. Thank you very much.
Thank you very much indeed. It was such a pleasure. Thank you.